The petitioner Tristan appears in the office of her attorney, Joshua Andrews. Susan Locke appears separately from her client, Joshua Niblett. All appear by Zoom. This matter comes before the court at this time for further proceedings, apparently in regards to a motion to modify temporary order.
Is asking that the court modify the temporary order to require both parties to be obligated to the remaining portion of that lease.
Does the temporary order address this issue?
The temporary order has each party being responsible for their individual residence, which each party is currently responsible for their own individual residence. However, the parties entered into a one-year lease agreement when they were residing together in Georgia. Mother then moved to Kansas, leaving father in Georgia. Father moved to Arkansas to be closer to the minor children, rather than in Georgia and Kansas. They're in Arkansas and Kansas. The lease goes until February. And so he is asking that the court make each party responsible for one half of that lease until it is up in February.
Guys, today we're diving into a heated court motion where both sides clash over a lease after their split. The judge wastes no time setting the tone, making it clear this won't be a routine hearing.
All right. Backing up a moment, Ms. Locke, what are the agreements that were reached regarding modifications of the parenting plan?
Sure, Your Honor. The parties have agreed that mother will have the second weekend of every month. That father would have the fourth weekend of every month. There's a divided residency situation, so that means they'll meet to exchange the kids, and all the kids would be together during those weekends. They've agreed to divide equally the breaks, so that would be summer break, Christmas break, and then they've agreed to rotate Thanksgiving. And I think that covers the parenting time modifications. There's some additional details, like as far as exchange location and times that the parties have agreed upon.
Mr. Andrews, would you add anything or dispute anything that Ms. Locke has laid out regarding the parenting plan?
No, Your Honor. Other than a modification that we agreed to today, which was that the parenting time during the school year would be that Mr. Niblett would receive the second full weekend of each month with all three children. Tristan would receive the fourth weekend of each month with all four children, and that the parenting time would be extended to Monday at 4:30 p.m. if there is no school in session on that Monday. All of the other agreements regarding parenting time, holidays, they've all been reduced to writing through exchange of emails. So I don't have any doubt that there's not going to be any confusion as to what we had agreed upon, since we have that in writing.
Is the term weekend defined?
Yes.
What is your definition?
Your Honor, the parenting time starts Thursday at 7 p.m. and ends on Sunday at 4:30, which is part of the exchange times.
All right.
So that would be the definition.
Court's real question is, Ms. Locke, is what is the second weekend of the month? For example, if
Your Honor, I don't know.
Month ends on Saturday the 31st,
it's my end,
Sunday the 1st. Is that the first weekend, or is it the first time Saturday and Sunday both fall in the same month, or what is the definition of second and fourth weekend?
And Your Honor, that is not something that Mr. Andrews and I had discussed, but I think we'll be able to reach an agreement about how that is to be defined.
Mr. Andrews?
It looks like he might be frozen.
All right, the court was discussing what the definition of weekend is. Unless the parties reach a different agreement, second weekend will be defined as the second time within a calendar month that both Saturday and Sunday fall within that calendar month. The fourth weekend will be defined as the fourth time during a calendar month that Saturday and Sunday fall within that particular month. All right. And then the new child support number would be what, Ms. Locke?
It is, I just clicked away from that. I apologize. Give me 1 second.
Your Honor, it's $1,268 per month.
Yes.
Effective when?
Your Honor,
we did not discuss that.
ask for it to be retroactive to the date of the filing of our motion to modify the first of the month, which would be September 1st.
Any objection, Mr. Andrews?
Your Honor, the concern is that may result in an overpayment, and this is a temporary child support amount. What I would ask instead is that the effective date be October 1. However, the court to reserve jurisdiction over any overpayment or over the issue of whether it should be retroactive back to the day of the filing of the motion and disposition of that overpayment.
All right, so your client's already received the full amount of child support that was originally ordered for the month of September?
I believe so, because I believe that an income withholding order was issued by the DCF, if I'm not confusing my cases.
All right, Ms. Locke?
Your Honor, I believe an income withholding order has been issued, and I know that my client privately remitted catch-up payments based on the original child support order from July. So he paid the months that were not caught by the income withholding order already.
Right, and I was thinking that he was effectively current on his child support obligation. So I would just ask if we reserve the issue of child support payable up to October 1 until a later date, final order to be resolved either as an overpayment or not. Since
The child support order is effective October 1st. All right. You've addressed some of the issues. Mr. Andrews, I'm curious about what your client's position is regarding this Georgia lease.
Your Honor, we essentially take two positions regarding that. Number one is we dispute that the reason Mr. Niblett moved to Arkansas was because of Ms. Niblett's move to Kansas. Instead, we believe that Mr. Niblett sought and obtained a better position within his company that required a move out of state, and that move was to Arkansas. He took advantage of that improvement in his position, and so he should be responsible for the lease payments that resulted from that decision. While it's true Ms. Niblett did sign the lease to Georgia, this was a situation where Mr. Niblett's the one who chose to take the job and move to Georgia. Ms. Niblett did move down later. I think it was approximately 1 to 2 months after he had moved to Georgia that she did, but it was only for a brief amount of time before she then moved back to Kansas. The second issue is that there's a sizable disparity in income in this case. Mr. Niblett's gross income is $8,750 per month. His net income Ms. Niblett's gross income is $3,001 per month, pursuant to the child support worksheet. So he makes $5,749 more per month gross income than she does, and this is a case where we did not seek spousal support, despite the fact that this is a relatively long-term marriage and there's a significant disparity in income. We do not believe that the expenses on the domestic relations affidavit are entirely accurate regarding his ability to pay the Georgia rent. We would note that one of the expenses is $250 per month for school expenses, which would be $3,000 per year for one child. That seems excessive. Another is property tax is $247 per month. That's $2,964 per year for what would only be personal property taxes, since there's no real estate, I don't believe in this case. Again, that seems excessive.
Both sides admit it's empty, but the bills keep coming, tightening the pressure on both parents. Then, in a bold ruling, the judge divides responsibility by income. 72% to the father, 28% to the mother.
Further, the credit card payments that are noted, that the total of the credit card payments was $1,278.94, but Ms. Niblett has indicated that Mr. Niblett would routinely put most of his expenses on his credit cards and then pay those expenses off at the end of the month, meaning that we believe that a number of the expenses included on the domestic relations affidavit are actually paid by the credit cards and then reimbursed through the credit card payments, which effectively is doubling up on the expenses on the domestic relations affidavit. So for example, he spends $800 per month in food, but if that's being put on a credit card and then he's making payments on his credit card, he's getting credit on the domestic relations affidavit for the $800 a month in food, plus the credit card payments that's paying the $800 a month in food. And so for those reasons, we believe he has the ability to pay this Georgia rent, and that based on the disparity in income, it would be fair, just, and equitable for him to pay the Georgia rent since he's not paying spousal support. And further, we believe that the fact that he has two rents was a decision he made in order to better his financial prospects and not because of Ms. Niblett moving back to Kansas.
Mr. Andrews, wouldn't you concede that once Mr. Niblett takes $1,268 a month out of his net income, transfers it to the net income of your client, that income gap, as a practical matter, narrows considerably?
I wouldn't say it narrows considerably, Your Honor. It narrows, but I wouldn't characterize that as considerable, given the fact that it's a pretty sizable. I mean, he grosses approximately $70,000 more per year than Ms. Niblett. I don't think that $1,296 a month in child support, helping her pay for the expense of the children, noticeably narrows that gap. So I would say that this is a case, typically there would be at least contemplated a spousal support obligation, given the disparity in income and the length of time these parties have been married. But we are not seeking that because we know that Mr. Niblett has expenses such as this Georgia lease payment. So I guess what we would ask is that if Mr. Niblett is going to ask that Ms. Niblett pay half of his expenses, that he provide spousal support.
It's like you're attempting to make what I think is perhaps a final issue in this case, a temporary order issue. Why does this lease issue need to be decided now?
Your Honor, the lease ends technically in February, so the party's obligation is through February. So we're asking the court to deal with it now because it's possible that the case will not be resolved by the time the lease is no longer an issue.
Okay. Have the parties completely moved out of the property?
Yes, Your Honor. My client has relocated to Arkansas, and obviously Mr. Andrews' client moved to Kansas some time ago.
All right. So both parties are, I guess, in default on the lease at this point, or are the lease payments being made by someone?
The lease payments are being made.
By your client?
Yes, Your Honor.
And I guess that would be another issue is I don't know what Georgia landlord tenant law is, but at least under Kansas, if you terminate the lease early, there's a obligation of the landlord to relet that property as soon as possible and terminate, at which point the lease payments would terminate. It can't just be left empty and allowed to collect those lease. So if the parties terminated the lease early, they're obligated on that under those lease payments until the property is re-rented. But I would expect that the landlord's going to re-rent that property, thereby obviating the need to pay the rest of the lease.
But that doesn't relieve the pressure of paying two leases until the property is relet, if it is relet during the contract period.
Plus, this court isn't aware that Georgia law would be as enlightened as Kansas law might be in a corresponding situation. The court determines that both parties are equally obligated under this lease. However, that there is a disparity in income which this court should consider. The court will require that beginning with the lease payment that would be due for the month of October of 2025, the parties will be responsible for payment of any lease payment due to the landlord in Georgia in proportion to their respective incomes as reflected by the most current child support worksheet. What is that percentage under the current worksheet, Mr. Andrews?
28% for Ms. Niblet, 72% for Mr. Niblet.
That will be the proportion ordered by the court. All right, Ms. Locke, you were the attorney for the movement for today's proceedings. I trust that you would be drafting a journal entry stemming from today's proceedings, which modifies the parenting plan, modifies the existing child support order with a revised child support worksheet attached, and then setting forth the proportionate share of the lease payment as ordered by the court today. Is that correct?
Yes, Your Honor.
All right. And you have in your possession the actual updated child support worksheet prepared by Mr. Andrews. Is that also correct?
I have one that has handwritten modifications to it, so I would just ask that the actual modifications be made, and then, yes, I will have it.
Bradley refused to let me make the modifications. I don't know why, but it would not work. It would not save. That's why it's handwritten in.
I'll see if I can recreate it, and then, yes, I will have it.
I spent, I would guess, a good 20 minutes trying to figure out how to get that to work on Bradley, and it just would not work. So I decided I would go old school.
And Ms. Locke, if you can't make it work, and you very well creatively may be able to, a handwritten one is fine as long as the parties agree on the handwritten modifications to anything that's printed on the worksheet.
Understood.
We are talking about a temporary order here. So some flexibility, I think, is called for under the circumstances. Counsel, are we going to eventually need a trial date in this case on issues arising or still existing in the case?
I don't know. I don't think that I can answer definitively one way or the other whether this is going to be a case that has to go to trial. I still believe that we could work out an agreement. We kind of focused on resolving this temporary order issue. I spoke with Ms. Locke before the hearing that my next step is to start gathering the rest of the documents I need in order to submit a property settlement agreement, property settlement proposal. I think that we've pretty much, with this agreement, resolved the residency and parenting time issues. I'm not expecting that is that this agreement is meant to just only be a temporary agreement that's going to be modified prior to the final orders. I don't want to speak for Ms. Locke on that, but at least I'm optimistic that that's not going to be a contested issue. And I still think that once I get some additional information to make the proposal, that there's a good chance of success at settling the case.
All right. Ms. Locke, do you see things differently at this current time?
Not at this current period of time, Your Honor.
Very well. Then I'll allow counsel some opportunity for further discovery and further negotiation with the optimism that a comprehensive agreement may eventually be reached in the case. Then you can inform the court that you'll need an appropriate hearing date. All right, the court will look forward to receiving Ms. Locke's modification order with child support worksheet attached in the court's queue in the near future. Mr. Andrews, is there anything else we need to address at this time?
Not to my knowledge, Your Honor.
Ms. Locke?
No, Your Honor.
Very well. Then at this time, the Niblet matter will be in recess and the meeting can be ended for all.
Thank you, Your Honor.
Thank you.
The attorneys scramble to finalize new paperwork while hoping to avoid trial altogether. The judge encourages resolution over rivalry, signaling this long battle might finally calm down. It's a quiet but meaningful, close to a tense hearing that started in conflict and ended in cautious optimism. Don't forget to like this video, subscribe for more courtroom stories, and we'll see you in the next one.